Welcome, and thank you all for joining us this evening. My name is Denise Jorgens, and I'm the director here at International House at the University of Chicago. On behalf of the International House community, we are so pleased to again partner with our longstanding collaborator here on campus, the Posen Family Center for Human Rights, and to welcome the renowned freedom fighter, anti-apartheid activist, advocate, and writer, Albie Sachs. Welcome. A quick bit of background on International House. This is a special year for the International House community, as the first International House in New York City is celebrating their 100th anniversary. International House of Chicago was founded by John D. Rockefeller Jr. in 1932, and so our 100th anniversary is only a few years away. And I was just in New York last week celebrating with my colleagues. From the day International House opened its doors, our mission has been to promote cross-cultural understanding, mutual respect, and friendship among students and scholars, and on the part of the people of metropolitan Chicago and the broader communities that we serve toward individuals of all nations and backgrounds. This part of our mission we've always taken very seriously. In fact, it's in our original gift letter from Rockefeller, where he says, "And you will be a resource to the people of metropolitan Chicago." Through the International House student life experience and our internationally focused public programs, such as this evening's event, International House is dedicated to transforming people's lives for a better world. This mission is then further extended through the work of the International House's worldwide organization, which we are pleased to say is today a network of 16 international houses on 4 continents. We invite you to join us here throughout the remainder of the academic year for many of our other Global Voices, Performing Arts, and Lecture Series programs, including special programming during Alumni Weekend, when we will host a discussion on the frenzied first 100 days covering Trump in unprecedented waters, moderated by John Carl of ABC News. Information about all of our upcoming programs is in the foyer area and on our website, where you can also sign up to receive our weekly newsletter. On behalf of the Global International House community, I want to welcome you again and thank you for joining us. And now I'd like to invite Professor Kaushik Sundararajan, Professor of Anthropology and of Social Sciences and the College and co-director of the Chicago Center for Contemporary Theory, to formally introduce this evening's program. Thank you.
Thank you, Denise, and thank you very much to iHouse for hosting us. We're really happy to be here. So good evening, everybody. My name is Kaushik Sundararajan. I'm a professor of anthropology and the chair of the faculty board at the Posen Family Center for Human Rights here at the University of Chicago. And it's my great pleasure and privilege to welcome you all to this evening's lecture by Justice Albie Sachs, and a pleasure to invite and to welcome Justice Sachs and his wife Vanessa September, who are spending the week in Chicago with us. It's a delight to have you. So before telling you about the evening that we have in store, I wish to inform everyone that this is one of 3 events that Justice Sachs is doing on his visit to Chicago. Tomorrow evening, Justice Sachs will be speaking at the Elastic Arts Foundation, a wonderful community jazz space in Logan Square, as part of an evening on art and justice. Justice Sachs will speak about the art collection at the South African Constitutional Court and its importance in the history of the anti-apartheid struggle, and his talk will be followed by a wonderful jazz performance that has been put together by the director of Elastic Arts, Adam Zanolini, a tribute to the South African jazz musician Johnny Diani, with an ensemble that includes the legendary singer Dee Alexander. So, an evening that includes Albie Sachs speaking and Dee Alexander singing is a special treat that is not to be missed. And I hope that some of you can make it to that event. Doors will open at 6:30 p.m. for a 7 p.m. start, and tickets are $15 at the door, but free to students and to members of Elastic Arts. On Thursday, at the 17th, at 12:15 p.m., Justice Sachs will speak at the law school in a session titled, Are We Going Forward or Backwards? Introduced by Professor Tom Ginsberg and moderated by the director of the Human Rights Clinic at the law school, Professor Albie Sachs. That event is free and open to all and is intended especially to be a student-facing event, so I hope a number of you can make it to that event as well. This evening, I will provide a brief introduction to set the stage for our event. I will then hand over to Professor Tuto Tipe, Assistant Professor in the History Department, who will introduce Albie Sachs. Justice Sachs will then present his lecture, titled You Can't Do That, Mr. President, How South Africa's Highest Court Held President Mandela and His Successors to Account. We will then have some time at the end for questions and answers. So in my introductory remarks, I wish briefly to do three things: give thanks, set the stakes, and introduce and hand over to Professor Tipe. Thanks first. An event such as this, indeed a week of events such as this, is like planning a wedding, with many moving parts, and I'm grateful that we have the most remarkable wedding planner at the Posen Center in Clifford Chan. So none of this would be possible without Cliff and the team at the Posen Center. So my heartfelt thanks to Cliff, to the Executive Director of the Posen Center, Professor Kathleen Cavanaugh, the Deputy Director of the Center, Adam Avrushin, who has managed many of the behind-the-scenes logistics for the week, and our Director of Communications, Peter Baker. I would also like to thank Adam Zanolini for providing us Elastic Arts for tomorrow's event, and for partnering with us to make tomorrow's event a genuine improvisation, and Aikan Nguyen at the law school, who has put together Thursday's event there. Thanks again to International House for providing us this space, one of the nicest and most significant spaces on campus for tonight's event. The iHouse is an institution that embodies and celebrates a cosmopolitan ethos, and goodness knows we need that. I also want to acknowledge the fact that Albie's relationship with the Posen Center is not a first acquaintance, but a reacquaintance. He was the first inaugural Posen visiting professor in 2007, and somehow decided that coming back every winter for the next 4 years would be a fun thing to do, back when Chicago winters were cold. So I would like to acknowledge, as part of the institutional history of this acquaintance and this center, the work of Susan Zesch, who first brought Albie to the center. I also wish to sincerely thank our co-sponsors who have helped make this week possible. The lead support for tonight's event comes from the Chicago Forum for Free Inquiry and Expression, and this talk is part of the Forum's Zell Speaker and Event series. I thank the Zell Family Foundation, which supports the series, and Professor Tom Ginsberg, director of the Forum, for his support for tonight's event. I wish to thank the University of Chicago's Division of the Social Sciences and Dean Amanda Woodward. Dean Woodward has been enthusiastic about Justice Sachs' visit ever since Tuto Tipe and I proposed it to her, and we're deeply grateful for her support of this event and indebted to the division's support of the Posen Center. Thanks are also due to the Global Human Rights Clinic at the University of Chicago Law School and the clinic's director, Professor Anjali Parin. Professor Parin is a force of nature, a teacher, thinker, and practitioner par excellence, and I'm grateful for the clinic's co-sponsorship and also for her own participation in the dialogue with Justice Sachs on Thursday. I thank the Department of History, and especially Professor Adrian Johns, for their generous support. I thank UChicago Global, especially Kate Moore and Amy Sato, for lending their support as part of their mission to help build and strengthen global collaborations and partnerships through the university. Sincere thanks to the Dean of the College, Melina Hale, for the support that the college provides to the Posen Center. And last but not least, thanks to Anne and Richard Posen for their generous support of human rights research, practice, and education in the university over many years. And now, on a more somber note, the stakes of this evening. any talk by as distinguished and august a guest as Albie Sachs is an important event in itself. And as Albie celebrates his 90th birthday this year, our invitation to him is also a gesture of admiration for him as a jurist, thinker, and person. However, we must acknowledge the auspices under which we meet, which I believe makes this talk not just a celebratory event, but also an urgent one. When a government starts arresting people without due cause and abducting them without due process, when a government deports people to another country, when a government professes an unwillingness or inability to rectify that deportation even after admitting it was a mistake, when a government violates a court order to do so, then the rule of law of the polity that government administers is no longer under threat. It has ceased to exist. That polity then is under rule by law, not rule of law. It is important to recognize the distinction between the two. Rule of law is a principle of radical equality, one that insists that everyone is entitled to certain basic liberties of thought, expression, and freedom of movement, regardless of their political views, regardless of the color of their skin, regardless of what tattoos they might wear on their bodies. That insists also that everyone is equally accountable for violations of the law, regardless of their wealth, position, stature, or popularity. Rule by law, by contrast, is an arbitrary suspension of liberties for those who are deemed not to have them. Process or certitude of violation or establishment of guilt be damned. Under rule by law, anyone can be stripped of their liberties at any time. No one is safe. It is important for a polity to recognize when it has passed from a rule of law to rule by law, if freedoms are to survive. It is important to recognize that such passage is not unprecedented and has happened in other times and other places. And it is desperately important at such moments for a polity to shed its insularity and parochialism and be willing to learn from elsewhere. It is a great privilege, but also an urgent necessity, to hear and learn from a freedom fighter from elsewhere. From a freedom fighter who participated in a struggle against rule by law for decades, who helped envisage what a rule of law might look like when the struggle for freedom would be won, and who was involved in the constitution of foundational norms and institutions that enabled the transition of a society ravaged by rule by law to one governed by the rule of law. It is a great privilege and urgent necessity to hear from Albie Sachs. I will leave a more proper introduction of Albie to Tuto. The ethnographer's privilege is that they get to hear stories. In my own current work on the relationship between health and constitutionalism in South Africa, I have had the privilege of hearing many of Albie's. There are stories of triumph, and the one he told me of being in a football stadium in Maputo in 1976, when Samora Machel, the leader of the newly independent country of Mozambique, shouted, "Viva o povo unido desde o Ravuma até o Maputo. Long live the people, united from the Ravuma to the Maputo." And 60,000 arms went up into the air in triumph. That story still sends thrills up my spine. Reminding us that the story of the anti-apartheid struggle is a story not just of South Africa, but of the world. But there are also stories of mourning, too many stories of mourning in the struggles that he was a part of. The assassination of Chris Hani, leader of the South African Communist Party in 1993, which nearly unraveled the tenuous peace negotiations underway between the apartheid government and the African National Congress, and nearly sent the country spiraling into civil war. The assassination of Albie's friend and comrade, Ruth First, in Maputo in 1982, by a parcel bomb planted by South African police. The assassination of the great student leader and thinker of Black consciousness, Stephen Bantu Biko, at the age of just 30, after being brutally beaten in police custody in 1977. The killings of the Sharpeville massacre, of the riots in Soweto, the killings of too many people who paid the price for wanting freedom and for making that desire known to those who would not give it to him, too many people whose names we cannot know. The attempted assassination of Albie himself by a car bomb planted by the South African security forces in 1988. Let us remember, at a time when the United States was fully complicit in the support of apartheid because it suited their geopolitical interests. It's a great privilege to have Albie speak to us, And I'm immensely happy to hand the floor to Professor Tuto Tipe, who will introduce Albie. Tuto is an assistant professor in African history in the Department of History at the University of Chicago. Her book manuscript in progress, titled Black Freehold, Land Ownership in Alexandra Township, is a fascinating and important history of the story of Black land ownership in Alexandra Township near Johannesburg, from 1912, when freeholds were established, to 1979, when the apartheid regime stripped Black landowners of their freehold and forcibly removed and displaced Alexandra's residents. Tuto tells the story of what a threat Black land ownership was to a white supremacist order, the residual legacies of which endure in a country where 80% of the land is still owned by the white minority, which comprises just 7% of the population 30 years after the end of apartheid. And importantly extends that story of dispossession, which is often thought of as being a predominantly rural story, to a historical attentiveness to urban and peri-urban zones. Yet hers is not just a story of relentless violence, as her work attends to the everyday intimacies of Black life, home, family, kinship, community building, even as it opens up serious political questions about the relationship between transitional justice and reparation. This will be an important book when it is published, not just for South Africa, but for the world, and I can't wait. Tuto was in many ways my partner in crime in helping to conceptualize and actualize Albie's visit to Chicago, and it's my great pleasure to ask her to introduce our speaker for the evening, Justice Albie Sachs.
Thank you for that incredibly generous introduction, and thank you for everyone who's helped make today possible. It's such a privilege and an honor to have Albie here. I know him from South Africa, and it's extraordinary to be here with him at the University of Chicago. Albie Sachs, as I'm sure many of you know, has been one of the most influential thinkers in shaping understandings of constitutionalism and the rule of law that have taken root in democratic South Africa. For more than 7 decades now, he has thought about, organized around, litigated, and adjudicated over how law can be used as an instrument for realizing liberation grounded in upholding human dignity. A bit of a background to how Albie came to be Albie. Albie was 17 years old. I call him Albie from the South African context. He's very anti-hierarchical. And even when people call him Mr., I've never once heard him, in many times, correct anyone and say they should call him either doctor or justice, which we probably should be. But but in the South African tradition, Albie was a 17-year-old student reading towards his legal bachelor's at the University of Cape Town when he was arrested for the first time in 1953 for leading a group of anti-apartheid activists to sit on benches designated for quote-unquote non-whites only. He came into his activism as a volunteer in the African National Congress's campaign of defiance against unjust laws, the largest scale non-violent resistance that had ever been organized in South Africa at the time, and the first campaign pursued jointly by all racial groups. After law school, as a young lawyer, Albie defended activists from the African National Congress, the ANC, the Pan-African Congress, and the trade union movement, and was the only advocate to appear in the Native Administration Court in Langa, Cape Town's oldest and at the time largest Black segregated township. As a result of his work in the resistance struggle, Albie was arrested in 1963 and held in solitary confinement for 168 days. In 1966, he was arrested again, and after 2.5 months in solitary confinement, he left South Africa and began what would be more than 20 years in exile. While in the United Kingdom, where he earned his PhD in law and worked in various academic positions, Albie continued in his political organizing towards the South African freedom struggle, including publishing widely on his reflections on living under apartheid's brutality, the role of law in colonial repression in South Africa, and different conceptualizations and expressions of law and community justice, among many, many others. His books are really worth reading for those of you who haven't. It's a really wide body of scholarship. Albie returned to the African continent in 1977, first as a law professor at the Eduardo Mondlane University in Maputo, then in the Mozambique Ministry of Justice. His return coincided with the shift in the 1980s in the African National Congress's attention in exile to actively conceptualizing and drafting the framework for a constitution to govern South Africa after the fall of apartheid. From 1986, Albie served on the Constitutional Committee within the ANC, and with other members of the committee, began drafting the constitutional guidelines for a future democratic South Africa. Following years of drafting and meetings with different stakeholders in exile around the Constitution, Albie returned to South Africa in 1990 and took part in the Convention for a Democratic South Africa, the formal negotiations towards a new dispensation. Albie served as a justice of the Constitutional Court of South Africa from 1994 to 2009. As one of the first justices of South Africa's Constitutional Court, Albie was part of a cohort charged with testing, interpreting, directing the application of the Constitution's principles. Albie wrote over 55 judgments in his own name. His judgments have been quoted in courts around the world, and in a series of institutions have bestowed awards on him, recognizing his political and legal activism, his leadership, and which are sincerely too long to name here, but a number of governments, universities, George and Elmo Clooney, a host of people have come together to recognize Albie's contribution to legal thinking and political thinking around the world. Through his publications, his judgments, his work in the arts, Albie has offers incisive insights into fascism's structural and jurisprudential underpinnings and its inner workings. But perhaps even more importantly, to understanding what needs to be defeated, Albie has given the world honest appreciation of the cost of fighting repressive governments, the liberatory, transcendent value of restorative justice, and the life-giving work of believing in and working towards a society that, as the South African Constitution says, is, quote, founded in the values of human dignity, the achievement of equality, and the advancement of human rights and freedoms. I'd like to close with a few words by Albie himself before turning over to what you're all here for today. Albie said, "What are we fighting for if not the right to express our humanity in all its forms, including the sense of fun and capacity for love and tenderness and our appreciation of beauty in the world?" So I look forward to hearing today what we're here to fight for. Albie never disappoints. I'm sure tonight will be the same as always. It's a great honor to welcome to the podium Justice Albie Sachs.
Wow. What a guy. It's actually quite thrilling for me to be back again at the University of Chicago. It's wonderful that I can get here without trudging through snow. People thought I was actually certifiable to voluntarily come to teach in January, 4 years running. I loved it here. I loved the intellectual sparkle. I loved the energy. I loved being disdainful about Chicago. The very first time I came here, it would have been in the late 70s. And I'd been in Mozambique, and I became a coffee addict in Mozambique, and I asked for an espresso. Now, some of you won't believe me, but I was told, sure, we can get an espresso. We drove around for 5 minutes, 10 minutes, 15 minutes. By then, I wanted to give up. But, you know, Chicago people never give up. So against my will, we drove for 1 hour looking for an espresso, and we didn't find it. And I mention that partly because it's an indication of the way the city's changed. I've seen it change in so many ways, with an energy, a vitality. It's no accident that Barack Obama came from Chicago and was able to reach out to the whole nation in a way that very, very few presidents have. And it's been a joy for me to notice the changes and to see my friends getting older with that same naivety and vision and hope for the future. And so it's thank you, Chicago. Thank you, University of Chicago. I had some great conversations at this university. I don't know, one just popped into my head. It was with, I won't go into it. Let's start, let's start with, I hope you know the president I'm going to speak of tonight. It's not a president with whom you will be probably just a teeny-weeny little bit familiar. I'm speaking about South Africa. As a judge visiting the US, I don't comment on your Supreme Court, the judgments, things that are going on here. We don't like it when people come from abroad and comment in a way on our justice system, particularly if they're judges themselves. There's a kind of, not a sense of comity, but almost propriety. The title's a bold one. Doesn't say, watch out, Mr. President. You can't do this, Mr. President. I tried and lost to soften the title a little bit, to say, you can do this, you can't do that, Mr. President. But I think you guys wanted something tougher, something tougher. I begin in a hall maybe 4 times the size of this platform, low ceiling. 2 offices in a ordinary commercial building with the wall between them knocked down to create temporary base for the new Constitutional Court of South Africa. We had Parliament in Cape Town, old building, very kind of colonial, late Victorian style. We had the presidency in the Union buildings in Pretoria, Edwardian style, quite attractive. Slightly new incumbents from what they'd been before. But we had a new constitutional court, 11 judges, 1 acting judge, without a home. So we had a temporary accommodation. We couldn't postpone adjudication until we got a building. So we occupied that temporary accommodation. It meant 11 judges. We each allowed 3 family members, close people, a few more other people, top judges, some press people, squashed together, perhaps with more intimacy than you normally get on an occasion like this, and a sense of moment. Nelson Mandela is there. He's going to inaugurate the proceedings. And he says, the last time I was in court was to find out if I was going to be sentenced to death. Today, I inaugurate South Africa's first constitutional court on which our democracy depends. We were thrilled to have him there, 27 years in jail, coming out, not leading us to freedom, but giving a beautiful public face to the freedom struggle, articulating with style and composure and humor and humanity and erudition the things we were hoping for, wanting. With that sense of, I'd call it proud serenity. You've believed something for decades. You've never given up. You've spent 27 years in prison. You've been breaking stones. You've been hidden from the world. It's been a criminal offense to even show your photograph in South Africa. You've been silenced in that way. But you've never lost that dream, that goal, that intensity, and that certainty. We used to say, Vittoria è certa, victory is certain. But that's just like a slogan. It wasn't just victory. Victory meant not simply bringing down apartheid, but creating a new non-racial democracy. So he's now speaking with that energy and volume and great internal comfort of the realization of a huge advance, a great breakthrough. And we judges now, we're sitting in our new gowns, and we're so pleased. The great Nelson Mandela is there with us, and he's launching the new Constitutional Court. I'd been in the underground resistance with him. Others had defended him. Others had known him from various conversations. And we all felt that glow. You couldn't have a better start. And how did we show our gratitude? 6 months later, we struck down 2 proclamations by President Mandela. No, Mr. President, you can't do that. Now that's gratitude for you. And the proclamations he'd issued, he'd been asked to do by Parliament. Parliament said in more legalistic language than I'm going to say, Mr. President, we have to prepare for the first democratic, non-racial, local government elections in South Africa. Before that, in 1994, we'd had the first one person, one vote in one nation, in one country elections. 20 million people voting as equals for the first time. Our independence didn't come with a flag going down, a new flag coming up, the band playing, a few people clapping hands, and the country's declared independent. Our independence came effectively from the destruction of that whole political system of apartheid, where whites had the vote, they controlled the parliament, they controlled the judiciary, they controlled the executive, they controlled the army, they controlled the civil service, and they controlled the police and the prisons and just about everything in the country. Now that's being shattered by the most participatory action you can imagine. 20 million people voting for the first time. Old people were dreaming of that day. One man we all read about was very frail. He was brought in a wheelbarrow in a rural area. He wanted to vote before he died. It was like huge. That was in April 1994. We're now in 1995, and it's time to have local government elections. And it's often at the local area that your rights are most affected. And we never had democratically elected local government. Mr. President, will you give a legal foundation for the elections? Ensure the money is there, secrecy is there, ballots are properly counted, all the things that you need, technical, practical, and also conceptual. We don't have time to do it ourselves. Everybody wants it. And he said, sure. And he issued the 2 proclamations. They were challenged by somebody who represented the opposition party, the National Party, the old regime, now in Parliament, and represented the Western Cape province against the national government. And we said, you can't do it. By a majority, a very large majority. Why can't you do it? Parliament can't entrust to the president the legislative authority. The Constitution says Parliament is responsible for legislation and sets out a whole range of procedures that have to be followed with public involvement, different readings, and so on. And then a section, Parliament chooses the president, then the presidency has certain powers. How was Mandela going to react? He had appointed us from lists given to him by our Judicial Service Commission. He'd been through so much. Who were these 11 judges thinking that they knew better than Parliament and the President, both other arms of government? I often say both arms of government, and I haven't even got both arms. The next day, we're told that the President's going to make an announcement on television. I don't know if the Supreme Court judges here watch television to see how their decisions are commented upon, but this case is the President himself is going to say something. And we're sitting, we're watching, and he says, in issuing these proclamations, I acted on legal advice that I had the authority to do so. I now accept that that advice was wrong. And I, as President, must be the first to show respect for the Constitution as interpreted by the Constitutional Court. Everybody knows the date of our first elections, 24th of April, 27th of April, everybody except me, 27th of April, 1994. Nobody knows the date of that announcement by President Mandela. Even I don't know the date, I don't remember the date. But to me, that date was as important as the day we voted as equals for the first time. Because the first time that made us a political democracy. With the President now accepting the overriding power of the Constitution as interpreted by the Constitutional Court, we became a constitutional democracy. That's case number one. Score, 0 to the President, 1 to the Constitution. Second case is known as the Hugo case. One of the things the President did, not long after he'd assumed his official position, was to issue clemency to prisoners. It's a kind of tradition in a number of countries. You do so as a sign of goodwill, of hope. And this wasn't simply a new president. It was a whole new social order. And this time, the clemency proclamation said all prisoners who are disabled and mothers of children under 12 who are in prison are entitled to be released immediately, provided they're not in prison for acts of violence. A father, Mr. Hugo, says, hey, what about me? I've got a 7-year-old child. This is unfair discrimination on grounds of sex. I see some people are nodding. We had two big issues there. The first, can the court review clemency granted by the President? And I remember doing a lot of reading of articles in journals in the United States. And the one article that really captured my eye was, can the President give clemency or pardon to himself? And the article was called Pardon Me. I was dying to write something just to get that joke in there. But in the end, it was Justice Goldstone wrote, Justice O'Regan wrote, Kate O'Regan, Richard Goldstone, and just Johan Kriegler, and it wouldn't have been, just for the sake of a joke, right for me to add something that wasn't in the other judgments, except having a nice little joke. So the main position, I think 10 out of the 11 judges agreed with it, was discrimination, but it wasn't unfair discrimination. And we created a jurisprudence on equality based on substantive equality, not formal equality. And what was particularly important was the role of the Constitution in tracking forms of hardship endured, pain suffered, indignities imposed upon people for being who they were. Being male, on the whole, guys had it better being male. Historically, women were the ones who were subordinated by sexism, by patriarchy. So he's not being excluded from that benefit because he's a man. The benefit being given to the women, who historically are the people who have been subordinated, is not being extended to him. He's not in jail because he's a man. He's in jail because of his offense. That was coupled with practicalities. There was something like, I think, 800 women in jail who had young children. There might have been 50,000 men. The 800, you could see who they were. And there's a kind of presumption that the woman, child, is the primary caregiver, the likelihood in that act of generosity. It would have been impossible to check up on the thousands of men. So it was really 800 women or nobody in practical terms. That was the decision of the court, except for one of my colleagues who said it was unfair discrimination, but not against the men. It was unfair discrimination against women because it perpetuated the idea that women are primary caregivers. And it is a very beautiful argument and a very powerful one, but I don't think the woman would have felt very excited to know that they're staying on in jail because women will be prejudiced by perpetuating. I just mentioned in passing in my own case, I'd been married to Stephanie Kemp, who'd been in the resistance. She'd blown up Ireland. She was in prison. She wrote very beautifully about her time in prison. And she'd mentioned how tormented and messed up the women were who were in prison. Everything about them was like a cascade of setbacks and failure in one way and another. The one thing that gave them a sense of dignity was their connection with their children. And I don't know if it applies here, but children, babies at breast, stay with their mothers in prison and run around. And Stephanie said, the only bright thing in this dismal world was the little kids running around and the love that the mothers had for their kids. So looking at things in that very practical, located, situated way in which I believe equality law should be looked at, not simply in a formal way, I'm comfortable with the decision we took. Ruth Bader Ginsburg was not comfortable with it. And I sense many people in this audience are not comfortable with it because you might say all or nothing. No gender, okay, so nobody must benefit because equality means you're not distinguishing between who the primary caregivers are on grounds of gender. So I was discussing this case in a little seminar that we had at one of the South African universities, and suddenly Ruth, who's known as this very quiet, little, nice person, was not quiet, she was little, she was a person, she interrupts me. And interestingly, people who've followed her life know that she developed equality law, focusing very much on the rights of men to look after their children, to get benefits and so on, to destroy the stereotypical division. The students were amazed to see former Justice Albie and Justice Ruth Bader Ginsburg fighting with each other. And by and large, Americans tend to be more robust, let me put it that way, than South Africans. Anyway, that was the second case. So that was one for the president, one each. The third case was the South African Rugby Football Union case. It was the clash of presidents. The president of our Rugby Football Union felt he was equal to or superior to the president of the country. Rugby was the game of the whites and very much of the Afrikaans-speaking whites in South Africa. And he made some contribution to change in the country. But the Minister of Sport at the time was dissatisfied. He felt there was still racism and there were some indications of corruption. So he proposed to the president that there be a commission of inquiry. And Nelson Mandela studied the documents and he proclaimed a commission of inquiry into what's going on in the South African Rugby Football Union organization. And Mr. Louis Late, a self-made millionaire, big person, very confident in all his modes of expression, goes to his lawyer, they go to court, and they challenge it. And they challenge it on grounds that those of us lawyers would know the administrative law of the apartheid era used quite a lot. And one of the grounds was you didn't give us a hearing. Aude alteram partem, you've got to give a hearing. The other was that he'd acted simply as a rubber stamp. He hadn't applied his own mind. He'd simply taken the document from the Minister of Sport and put his signature to it. And the matter goes to trial. And Nelson Mandela says, I want to testify. Mr. President, please don't. It's not usual. Don't do it. Don't do it. I want to testify. I want to show the president is not above the law. And he goes into the witness box. And he's cross-examined. Judge asks a few questions, very courteously. And the judge disbelieves him and strikes down the proclamation. The Minister of Sport takes it on appeal to the Constitutional Court. We're all getting ready to hear the matter, and his lawyers ask 5 out of the 11 judges to disqualify ourselves because we are too close to Nelson Mandela. We can't give an objective determination. Do you use the word disqualify? Recusal is the term that we use. Now, 5 of us withdraw. We don't have a quorum. A quorum is 8. So it means they win their case. It was actually extremely awkward. If any of you ever thinking of becoming a judge, I would say go for it. If you've got $20 million, I was going to say it won't be difficult, but it will be difficult. But one of the hardest things is to deal with an application that you step down, because you have to judge yourself. And even although you use the language of objectivity, in the end you're making an evaluation. In my own case, the grounds given were included that I and my wife had frequently had lunch with Nelson Mandela. When it came to my turn to speak, I said, Mr. So-and-so, to the council, I've been divorced for 10 years, and I've never had lunch with Nelson Mandela. But he found a response, and then I responded, and when we broke for tea, I remember my colleague Richard Goldstone criticized me for being drawn into that, a kind of spat with council. It was very, very unpleasant. But basically what the lawyers for the other side were saying was, if you'd been in the freedom struggle, if you'd fought for the Constitution, you were too close to the president to give an objective. So the only people left would have been those who were on the other side. We accepted that if we were really close, then we should step down, even if it meant the court wasn't quorate. But we weren't that close. We'd sworn an oath, we'd affirmed that we would uphold the Constitution. We were so super moral and super correct, we would have stepped down if the proximity had been too great. But it created an air of unease. We reject the argument, we hear the case. And now we're reading the documents, we're reading the cross-examination. We can't see how the judge was a very clever, adroit, and very courteous old guard judge. But it just didn't make sense. He made a finding of discrediting the witness, but the question and answer didn't justify that at all. It was a relief. If there had been a mess in the answers, well, we would have had to uphold that and say our president was somebody not worthy of belief, and allow the Commission Macquarie to be stricken down. It was also a great moment for us because we're now moving into a constitutional era. Before that, we'd been in the era of parliamentary supremacy. And we developed, the more progressive lawyers, all sorts of tricks at the very low level. You could challenge administrative action. You could challenge regulations. You couldn't challenge acts of parliament. You certainly couldn't challenge anything done by the president. And we had to recast our mind completely. And I remember saying to my colleague Kate O'Regan, we were working on one section, you know, Kate, we've now got a Bill of Rights. You don't need tricks. You don't need procedural devices. We've got a Bill of Rights. The Bill of Rights provides the parameters for fair dealings, including even a right to just administrative action. So, ended up, Mr. President, you had the power. We said there is no prerogative rights of the president, which had been inherited from the English judges appointed by the king, by the royalty, where the president could do, it was always he or she liked. Even the clemency has to be subjected to the Bill of Rights. So if there had been a class of people discriminated against on the ground of gender, we could have interfered with the clemency. If the president said, Kaushik, you've done terrible things, but you know, you've seen the wickedness of your ways, you've reformed, I'm giving you a pardon, and we think, that's impossible. Everybody knows what a terrible person he is. You can't challenge it in court. But if it says, he says, I'm going to give pardon to him because he belongs to a certain class or group or has certain origin or skin color, whatever it is, then we can interfere. So we made important law. My joke still hasn't been told in South Africa about pardon me. The score now, what is it? 2 to the president, 1 to the Constitution. The fourth case pharmaceuticals case. There's panic in the presidency. He signed into law a new Pharmaceuticals Act dealing with drugs, dangerous drugs, basically, control of medicines. And the act destroyed the old Medicines Act from the apartheid days, and it didn't create a new schedule of dangerous drugs. So the net result was there was no control, legal control, over serious drugs, of which we had plenty in the underground in South Africa. Heroin, mandrax, the lot. And he rushed to court, and his lawyer said the president had signed, but he hadn't been given proper legal advice, and the net result would be disastrous for the country. Please withdraw his signature, issue an order withdrawing his signature so that the matter can go back to Parliament and a proper schedule could be drafted and attached. The judge agrees to that. Bona fide error, not his fault, important for the country. It comes for us for confirmation. And we're worried. Imagine if a president can say, sorry, I made a mistake, I didn't understand the law, I was wrongly advised. The rule of law, you'd never feel comfortable, and it could be invoked for all sorts of nefarious purposes. We didn't like that ruling. Necessity. The phrase, necessity knows no law. I remember in Cape Town, where I practiced as a lawyer, we had an attorney, Mr. Cohen, and we called him Necessity Cohen because he had a big mouth, but he knew no law. Very dangerous doctrine. The minute you allow necessity, then it's brought in by states of emergency, suspend the rule of law, too much power. So we introduced a concept of rationality and rule of law. The effect of adopting this law was not to promote the law, it was actually to destroy the law. It was an irrational act. We sometimes debated, is the signature a legislative act or executive act? It's an executive act that's part of a legislative act. And we said that his signature was null and void because it purported to give force and effect to a document that called itself a law, but a document that actually destroyed the law. We thought it would be very, very rare where those circumstances would arise, and we wanted to keep it very, very rare. So I don't know who gets the score here. He lost the argument, but he won the outcome that he wanted. So should we say half and half? What does that make it? 3.5 to Mandela. The last case was a case, it's called the Liquor Bill case, where Parliament had passed a law to try and break the monopoly of South African breweries. They controlled 95% of production and sale of liquor in South Africa. They went on to buy Anheuser-Busch, and I think they went on to be bought out. I'm not sure what they are now, their name. And the idea was now to particularly allow black people to enter the liquor trade. And liquor is not sold at the national level, it's sold at the local level, provincial level. And Mandela now is president of the country. He's not president of the ANC. I mean, he is president of the ANC, but he's not acting in that capacity. And he says our constitution gives the issuing of liquor licenses as an exclusive power to the provinces. I remember we were looking to something to give the provinces. And somebody put up their hand and said, well, liquor licenses. And that's a lucrative source of income. Nobody knew it would lead to a crisis. And our Constitution doesn't allow the President the right to refuse to sign. The President can only refuse to sign if he thinks the law is unconstitutional. He can't say, I disagree with it, and go back to Parliament and get a 2/3 majority to override my refusal. All he can say is, I think it's unconstitutional, and he can refer it back to Parliament, which he did. And he said, these are my legal arguments. And Parliament said, we don't care. We're insisting it's not a matter of liquor license, it's a matter of trade, and trade is a national competence. Come back to us, and we agree with President Mandela. And I remember feeling a certain pride, a pride that our president was going against his party, a pride that he was doing something even against the interests of the community from which he came, because the Constitution didn't permit it. The Constitution rules okay. And it was setting a wonderful example. So that makes it, what's the score now? Yes to President?
Total winner.
Total winner. But the fact was that he'd lost one very, very important case, misconceived another very, very important case, and justified his position in the other cases very graciously. I won't say fast forward because I've taken some time to get there. Medium forward. President Thabo Mbeki, very thoughtful, brilliant in many ways, did a lot to create a sense of Pan-Africanism, helping to create the African Union, African Parliament, African Court, legality in Africa as a continent. He refused to accept that there was a virus causing what scientists call HIV AIDS. He'd read a Professor Duisberg, I think his name was, from California, who said it was really a concoction of the pharmaceutical companies. And this was having a very negative impact on response to people living with HIV, and in particular to distribution of antiretrovirals. Our people were dying in large, large numbers. It was so dramatic. We'd won our freedom, we'd got democracy, we're moving ahead, we're making all sorts of changes, and our people are dying. It was like a terrible kind of calamitous response by disease to so much that had gone into the liberation of our nation. And people on the ground now living with HIV got together. They organized, they formed the Treatment Action Campaign. Tens and tens and tens of thousands of people living in shacks, living in mud houses in rural areas, living with the virus, getting together, organizing, campaigning, literally on the ground. Strong support from journalists, investigative journalists, and strong support from lawyers, thoughtful lawyers. And the case they chose to bring to the courts was the case of provision of nevirapine, an antiretroviral drug, which if given to women about to give birth, cuts down the transmission of the virus, then about 50%. Now it's like 97%. And the Minister of Health, clearly under the influence of the President, was restricting the provision of nevirapine in the public sector to 2 sites in each of our 9 provinces. If you lived in the local area, you could get it. If you had money, you could buy it across the counter. But if you didn't have money, as most of the people didn't have, and you didn't live in those areas as most of the people didn't, you went without. They go to the High Court. The High Court rules in their favor. The matter comes on appeal to us. And we about to take our seats, and my colleague Sandile Ngobo says, Albie, would you like a handkerchief? And he takes a handkerchief out of his top pocket and he offers it to me. And I say, Sandile, it's not necessary. I'm prepared this time. The background to that was a few months earlier, we'd had a certain Mr. Hoffman applied for a job on South African Airways, passed all the tests with flying colors, but turned out he's living with HIV. And they said, we'll give you a job on the ground, but he wanted a job as a steward. That was his dream, to be a steward, to fly across the world. And they said, no, you've got HIV. What will British Airways, or what will our customers say? They'll go to British Airways that refuses to employ people living with HIV. Court, the matter ends up in our court. Our Bill of Rights includes a right of access to adequate health care, but it doesn't include an employment right. It doesn't say non-discrimination on grounds of medical status is unfair discrimination. Sorry, it doesn't require that. And Sandile is about to deliver the judgment which he'd written. The court is packed with people, men, women, young, old, black, white, brown, wearing T-shirts saying HIV positive. There's dead silence. And he just gave a beautiful extract from his judgment, saying, in effect, the prejudice of foreign airlines can't be used as a basis for prejudice by South African Airways. And labor is more than just occupation. It's part of a person's dignity, the right to work. Just beautifully phrased. We go out, dead silence, the curtain closes, and cheering starts. And I started crying. I was crying because of the impact of HIV in our country. But I was crying not because of that. I was crying because I'm a judge. When we'd written the Constitution, we weren't even thinking about HIV. But now the Constitution gives us the power to correct this massive injustice, not just because I think so, or my colleague thinks it's a good thing, or because the Constitution requires. It's just an overwhelming feeling. And I told that story when I visited Harvard afterwards, and somebody in Harvard, where Sandile had done a master's degree, wrote to him and said, you made your colleague Albie cry. So now he's offering me his handkerchief. And I'm saying, no, I'm fine. And Arthur Chaskelson, the Chief Justice, delivers a judgment and says, under our Constitution, we have social and economic rights. It includes the right of access to health care. And the state, every person has that right, and the state shall take reasonable legislative and other measures progressively to realize that right within available resources. If this is a matter of policy that in the old days was left to government and not to the judges, now it's policy that has to be compatible with the principles of the Constitution. And so we don't have a choice. We're required to uphold the Bill of Rights. Upholding the Bill of Rights means we have to declare that the restricting of the provision of nevirapine to 2 sites in the provinces of South Africa is unconstitutional. We were asked to give a structural interdict, and I remember Arthur saying, it's not necessary. We don't want to bloody his nose. It's enough just to declare if there's no follow-up action on the part of the medical people in government, then they can come back to us to get the interdict. Dead silence in the court, packed with people, HIV positive, HIV positive. We go out through the curtain, the cheering starts, and I cried again. So that's one against the president. And it had an enormous impact. The Minister of Health was speaking about defying. And the President told Mbeki, said, no, the court has ruled. The court has ruled. And we now have the biggest antiretroviral program in the world. We also have brilliant scientists working in this area. It's no accident that during coronavirus, the virus B was discovered in South Africa, because our scientists are good. Our scientists now are working on a vaccine and making very, very good progress. That's why the support that we've been getting ever since the time of George W. Bush, Republican president, for counteracting HIV has been so enormously important for us, and why any withdrawal of that support can have calamitous effects with literally tens and tens and tens of thousands of people dying unnecessarily, and a postponing into the distance of a vaccine that could save further infections. The last case I'm going to deal with, so what's the score now?
It's about 4.5 to 2.5.
Okay. Is, I'll start off by saying, I'm in Johannesburg, I'm rushing to catch my plane. I'm often rushing to catch my plane. And a big, burly, late middle-aged African man blocks my way. And he puts his arms around me. And he says, thank you, thank you, thank you. And I say, it wasn't me. I've been off the court for 6 years. Thank you, thank you, thank you. And the case was, it's known as the Nkandla case in South Africa. The president at issue, presidency was in the hands of Jacob Zuma. And we created an office in a section of our constitution that's called Institutions for the Protection of Democracy. Our constitution is unique in the world. Independent Electoral Commission, the Judicial Service Commission, the Auditor General, the Commission for Gender Equality, Human Rights Commission, it's another cultural commission. They all belong to that Chapter 9. They all created in a very special public way through Parliament, not through appointment by the government, but through Parliament. They all give a security of tenure to the people involved. It's played a huge role in protecting our democracy. And the public protector was one person like that, based on the ombudsperson from the Scandinavian countries, but with more powers. And the public protector had investigated the expenditure by Public Works on the private house of President Jacob Zuma to provide more security. He was entitled to that, but not to a swimming pool, not to a chicken run. You know, people used to joke. Not a joke, the Minister of Police said the swimming pool, in fact, was a fire pool. Couldn't explain why it sloped down, had blue tiles at the bottom. It was deeper at one end than the other end. And the chicken run, people joked, was if burglars came in, the chickens would go, they'd provide alarm. And she said that he must pay back the money. What Parliament had done, what Parliament did then was to set up its own committee who did the investigation and said, in fact, there hadn't been overpayment. In fact, all of these were justified. And in fact, he was owed some money. He'd paid some more from his private sources. So it's taken, Parliament's decision is taken on review, and the President's failure to pay is taken on review to the Constitutional Court. And I'm not on that court. The Chief Justice gives the judgment. His name is Mogoeng. He'd been appointed by Jacob Zuma, one of the few positions where the president has direct control, subject to an appearance before and the advice of the Judicial Service Commission. And he responded in very strong language. He'd been a lay preacher, but he said the president isn't just the holder of office performing certain functions. The president has to represent the values of the Constitution in everything that he does. And his example, if it's a negative one, is negative for the whole country. If it's positive for the whole country. Some phrase like, we must chop corruption off at the neck, is a very powerful statement. And that's why I was being embraced. And it came at a time of state capture. Afterwards, Commission of Inquiry went into it. It was quite clear the president was heavily involved in making appointments, allowing crooks to take over state-owned enterprises with calamitous results for the country. So the court at that moment stepped in. And again, it gave, we use the word, if South Africans here will know the word klap, a slap, to Parliament for not performing its oversight responsibilities as required by the Constitution, not accepting the report of the public protector, and to the president for getting an aggrandizement of his home that he was not entitled to. I must say, when journalists went there afterwards, they couldn't even see what all the money had been spent on. You know, it wasn't a huge palatial home. He'd been taken for a ride there. But it was a very important moment in the life of the nation. And it became the foundation stone for a fight back of all those who wanted to return to real democratic functioning and proper working of the different institutions. Some people say the court's overreaching, it's too powerful. But if you look at what the court was doing, it wasn't telling Parliament or the president what policies to follow, how to conduct themselves. It was telling Parliament to do your job. Your job is to provide oversight to the executive. It's different. Our Parliament chooses our president. It's more like the prime ministerial system. You get in India, you get it in Australia, in Canada, and Parliament has that role. But it's not called a prime minister, it's the president who does international stuff, has certain powers beyond those of the prime minister, can't just call elections when he or she wants, and so on, but really similar to that. And Parliament has to oversee that person. And Parliament wasn't doing that. And the president has to conduct himself according to the values of the Constitution, not just exercising powers that are given to him in terms of the Constitution. So the score then is?
It's about even, actually. 4.5 and 3.5.
4.5 to 3. So 4.5, Mr. President, you can. 3, Mr. President, you can't. And I mentioned that it's not an automatic anti-president thing. It's each case has to be determined on its own merits. And I'm happy to have shared that with you. And I'm going to ask, who's in charge here? Who's my leader? I need a quick comfort break. So I'm looking forward to the discussion that's going to follow. I don't know if, okay. But please may I leave the room, as we used to say at school. And where is the nearest bathroom?
Thank you for being here today. In this country, parties on the right and the left are divided and not as able to speak with each other or work with each other as they have in the past. You served on a court with fellow freedom fighters and also worked with and among those in the opposition who represented the regime under apartheid. My question for you is this: In the period of transition to democracy, how did you manage working with those who disagreed fundamentally with you on questions related to the Constitution?
So we'll collect a couple of questions and Albie will respond.
Hello, thank you so much for being here. My name is Erica Mora. I'm a second-year student here at UChicago, and I was wondering if there's any constitution from other nations that you feel can teach a little bit to the South African Constitution as well as the United States Constitution.
Hi, thank you so much for being here. This has been an incredible opportunity to listen to you and hear from you about your experience. There's been a lot of talk about a constitutional crisis that we're experiencing, or are we experiencing, in the United States, and wondering how you can define something like that. And when you're in the midst of a constitutional crisis, who in the government or civil society can help stand up to something like that? Okay,
let me start with the last one. Constitutional crisis. You wouldn't be thinking about the US of A, would you? Because I can speak about a constitutional crisis in the USA, but in the 1930s, not today. And the Roosevelt government, elected on the basis of the New Deal policy, was introducing massive social programs to help the unemployed, the migrant workers, the dispossessed. And the Supreme Court was striking them down. And it was creating a very serious position. And Roosevelt was speaking about enlarging the court. And it was very serious about that. And then one of the judges, it was 5-4 all the time, one of the judges moved over and somebody commented, "A switch in time saved 9." But it also helped to create a court that became a model for the world. And I would say the strongest moment was the Brown and Board of Education case, where the court did something for America of essential justice in keeping with what the Constitution meant, if it meant anything at all, but against the precedent of separate but equal and continuing discrimination. And many of us, I was a law student at that stage, and I was inspired by that. And I got a huge amount from the US Supreme Court. But let me say, I found less and less of direct relevance to us in South Africa as time went on. I love asking American legal people, who were the 2 American Supreme Court justices I found I was citing most often in my own judgments? Any lawyers here? Okay. Who would you say those 2 were? Brennan, okay.
Warren is the other guess.
Warren, no. No, Douglas, no. I think I quoted Douglas once, but Brandeis, no. Oh, come on, guys. Jackson. He wrote beautifully. He hadn't been to law school, so he hadn't had lyricism knocked out of him. He hadn't had passion denied to him. And it wasn't as though I was looking for Jackson. We would get the American consulate in Johannesburg gave us the Supreme Court law reports and Larry Tribe's book. The Canadians gave us the Canadian Supreme Court and Peter Hogg's book. We actually got an enormous amount from Canada because they got a Bill of Rights in 1982. Very progressive, very thoughtful, very modern-looking court that provided a marvelous template for us to look at for help. The other countries, okay, another question I like asking audience, I've never done it in North America. Which do you think would be the 5 countries from which we drew the most in creating our constitution, new constitution in South Africa?
India.
India was the second most important country for us.
Other guesses are Canada and Germany. People have
Canada and Germany, yes. Sweden? No. The Swedish Constitution gave us the least. After I was blown up and I'm out of hospital in London, and I'm invited, somebody asked me, what would I like to do? I said, I'd love to work on a new constitution for South Africa, preparing for it. And she was from the University of London Institute of Commonwealth Studies, and she said, we've got a bathroom, we can convert it into an office, we get money from Ford Foundation. Am I allowed to mention from Ford Foundation? I believe it's under attack at the moment. And Swedish International Development Agency. And I thought, let me go to Norway. I like Norway. It's a progressive country, it's a very open country, it's democratic, but with a strong community involvement.
Mm-hmm.
And I asked them about the constitution. Oh, yes, we have a constitution. When we separated from Denmark, we got a constitution, and when we separated from Sweden, but nobody uses it. It's just an important historical document. And then it was like similar in Sweden, and then Denmark. These countries I liked, and I thought we'd get a lot from. And I developed what I call my regicide theory of a Bill of Rights. That when the sovereign was executed, then sovereignty had to be articulated in a new kind of compact. And in these northern European countries, the rising bourgeois class did a deal with the royals. They stayed in power. The sovereign remained the sovereign, but effective sovereignty went to the parliament. And then what mattered was constitutionalism, practices, habits, part of the culture of the country, things you did and you didn't do. And if you ask me which country I'd rather be locked up in, France with a constitution, England without a constitution, the UK, or United States with a constitution, I'd rather be locked up in London than in Paris or in Chicago. So having a constitution itself isn't a guarantee. If the culture is one of constitutionalism, which is very strong in those countries. But what we did get from Norway was the ombudsman. We didn't like the term, and ombud looked strange, so we called the person the public protector with greater powers. Otherwise, we got very little from the Nordic countries in terms of constitutional texture. Okay, the country you've left out is the United States of America, and it became fifth on our list. The whole idea of a constitution, separation of powers, a court with testing powers, that comes from the US. Ruth Bader Ginsburg, who had a wonderful tour, and I was like her companion, Vanessa and I, in South Africa, got into big trouble when she went to Cairo to the time of Tahrir Square, the uprising, the Arab Spring, and they said, what can we learn from the United States Constitution that will be useful for our new constitution in Egypt? She said, don't look to us. We're a couple of 100 years old. Look to South Africa. She got 10,000 hate letters as a result, as a traitor. So in any event, so the US has the greatness of being the first country to have a constitution that was living and real and real functioning. Then that we got from the US. We got a lot from Germany. One was a big issue in South Africa was going to be who would have the powers, the central government or the provinces, states, whatever they were called. And the old white authorities wanted to decentralize as much as possible so they could hang on. By law, 87% of the land belonged to whites. Not whites used conquest or worked hard and used economic power to accumulate masses of land. By law, you couldn't transfer your house in most of Chicago, without the deed of transfer saying you're a white person transferring to a white person. The most banal act that a lawyer can have is just to do a deed of transfer. But it had to include the race, even for house transfers. So that had to be, you needed something drastic to change things in South Africa, to open up the schools, the hospitals, everything. And the whites were pushing very hard for federalism, at one stage pushing hard for freedom of association, and coupled with property interests, so that you would privatize apartheid through economic power being consolidated, and the state couldn't intervene to bring about any change because these would be protected fundamental rights to association and right to property. The white zones, including the whole of the central business district, all the beautiful areas of Cape Town with the beautiful views and so on, would remain in white hands. So we were envisaging massive change, dramatic change. We didn't get the dramatic change. We got significant change, and at least the possibilities of change. But we went to Germany, the Constitutional Committee of the ANC, the Friedrich Ebert Stiftung invited us. And Germany has a very interesting setup with regard to their foundations. They are political. Here they're political, but they pretend not to be political, to be absolutely neutral. There they're openly political. So the Konrad Adenauer Stiftung supported the, in South Africa then, the conservative, overwhelmingly white groups, the Strauss Stiftung supported Buthelezi, the idea of regionalism. Naumann supported some other group, the Democratic Party, and the Friedrich Ebert that had a strong social democratic, was set up by the Social Democrats, strong trade union, labor background, supported the ANC and gave us enormous help, not doctrinally, but financially, to travel, to visit, to see other countries. And we discovered in Germany, they have concurrent powers between the center and the Länder. And there's very few exclusive powers for the national, foreign affairs, currency, one or two other things. But land, agriculture, education, health, all of those things, trade, could be, there could be legislation in the Länder, like your states, and legislation at the national level. And if there was a clash, then there would be, a court could decide, was the national interest involved or regional. That was huge for us because it saved us enormous travail fighting over that issue. Then their upper house, we had a Senate before, and in Germany, the upper house consists of people sent by the Länder. The regions send their delegates to the Bundesrat. So it means that the center knows what's going on in the regions, and the regions know what's going on. And we have a National Council of Provinces. We got that from Germany. We also had the idea of a constitutional court, a court dedicated to constitutional matters. Your Supreme Court upholds the Constitution, Bill of Rights, and so on, but it also deals with other federal cases. We had a court at that stage. Now it's been given an enlarged jurisdiction, and it's collapsing the court because everybody sends their cases. They reject 90%, but they have to read all the documents over insurance and all the many things that people fight over where money's involved. So that we got from Germany. From Canada, we got the only people who told us, don't follow our example, were the Canadians. Everybody else felt their country had the best. The French, of course, had the best. The Americans had the best. The Germans had the best. The French said, don't follow us. Our provinces have almost total supreme autonomy, and we can't function as a nation. So outside of the constitutional text, we have a prime minister's meeting. It's not even in the constitution to deal with federal things. Go for cooperative federalism, not for competitive federalism. Look at Germany, look at Switzerland. So we got that useful negative advice from Canada, but we also got the way they dealt with the Bill of Rights. And when their constitution was what they call repatriated, it remained in London. In 1982, it was brought over physically to Canada. It now included a Bill of Rights. And I happened to meet Pierre Trudeau, the father of the Trudeaus, been in the news recently, in Cape Town. And he explained that one reason why he favored the Bill of Rights was he was from Quebec. Quebec nationalism was growing, and he felt if there could be a Bill of Rights that gave equal citizenship to all Canadians, English-speaking, French-speaking, wherever they were, rural, urban, it would enable the Quebecois to have a distinctive personality, history, legal system, but also feel Canadian. And it certainly worked in that way. And they had brilliant leadership from Dixon, is it Brian Dixon, and Bertha Wilson, who happened also to introduce a very strong feminist dimension to the interpretation. And that was very, very helpful to us. India, we got the most important thing, who drafts the Constitution? And India had a Constituent Assembly. It wasn't drafted in London. Mm-hmm. And it wasn't elected, as far as I know. Like, we insisted on a two-stage process of constitution making, that we would have national elections, 27th of April, 1994, to create a parliament, and parliament would draft the Constitution. So it's 490 people drafted our Constitution over a 2-year period. And we got the enemy, as we used to call them, to lay down their guns, to surrender political power on the basis that we would agree in advance to certain core principles. We would negotiate in advance. Those principles would be binding on Parliament drafting the new Constitution. It's a partial answer. How did you deal with your enemies? 2/3 majority required, and proportional representation to make even the smallest groups get into Parliament. And we wanted them there. In those days, everybody used to quote Lyndon B. Johnson. I'm not even going to try the Texan accent, but it was along the lines that we'd rather have the varmints in the tent pissing out than out the tent pissing in. And we wanted them there. We didn't want people to say this is not our constitution, it's an ANC constitution. And we got a huge majority, over 80%, for a constitution that included environmental rights. It included sexual orientation as a forbidden ground of unfair discrimination, and a whole range of socially progressive measures because of the time spent negotiating, discussing, and the rights that were important to the old regime. And even the language changed. We would speak about the enemy, and then we're making some progress. It became the regime. Then the regime became the bloody government. And finally, when we were in the ascendancy, we spoke about the other side. It was never a formal decision, but I just remember our language changing. We had breakdowns. In the end, the basic breakthrough came not round the table, but ANC withdrew from negotiations. There was rolling mass action outside, hundreds of thousands of mainly black people, mobilized, disciplined, organized in the streets, and the leadership of the National Party under de Klerk decided to accept our vision that I've just mentioned. But who would decide whether or not the principles had been agreed to? And I want to mention, if we speak about language rights, it wasn't a concession. We wanted language rights. If we spoke about free political activity. That wasn't a concession to win them over. We wanted that. These were things we wanted. We wanted an open and democratic society. And we wanted the concept, the vision, the possibilities of land reform and transformation built in without being able to declare that there's a revolution and we're going to grab all the land and give it to the people who work the land without benefits and so on. So we got the idea then of Parliament drafting the Constitution from the Constituent Assembly of India. It was a very, very important model for us. But we also got the Finance and Fiscal Commission for a very strange, oddball reason. One of our advisors came from a very old Dutch-based family, van Reineveld, lawyers in the family over generations. And he had a left-wing radical approach, belonged to a group called the Development Action Group. And he went to study in Amsterdam, and he met a woman from India, fell in love, followed her to India, and discovered the Finance and Fiscal Commission. Because one of the issues is, how do you transfer funding from the wealthy areas around Johannesburg to the poor areas where the migrant workers had come from, remain underdeveloped? We followed that. But the most important thing, in practical terms, we got from India was an independent electoral body. And we had a team came from India, and they gave us wonderful advice. You can't have government, the incumbents choosing the people who are going to guarantee the next elections. Mm-hmm. There's always going to be trouble. And we built in the idea of an independent electoral commission from the beginning. And we've had 7 elections that are free and fair. And I might say in South Africa, we pass laws to encourage people to vote, not to discourage people from being able to exercise the vote. And it's been what gives me confidence about the country, the openness, the institutions, the court, press. We're not a fair country. Race still plays a huge role connected with inequality. We're not a safe country. I wish we didn't have to lock up and be careful about walking in the streets at night, but we are an open country. And that is meaningful. It's not just pieces of paper. People speak their minds. In fact, it now often requires more courage to defend the government than to criticize in certain circumstances. Oh, you mean you agree with all the corruption, all this, that, and the other. So the Independent Electoral Commission came from India. But the number 1 country for precedent that we drew on was Namibia. And even in Namibia, they didn't know that they were number 1. And South Africans mostly don't know. And Namibia had been conquered by the Germans. The genocide was first practiced against Namibian communities. End of the 1914-18 war, South African troops had gone there. It became a mandate later on under the League of Nations to South Africa, a kind of trusteeship to South Africa, and a war of liberation. And eventually, the international community, there were 4 contact groups, Western countries, drafted some principles, which was called a white paper, that would have to be embedded in a new constitutional order in Namibia. They had elections, like we had elections. Their parliament drafted the constitution. We got that from Namibia. And it sounds very obvious. It's not obvious. With conservative thinking, all based on race, on tribe, and ethnicity, and power sharing between different ethnic groups and so on, we had to resist that. We had to go for majority rule with a Bill of Rights and very strong language, cultural, religious rights and so on embedded in a Bill of Rights. And we got that in South Africa. So Namibia was the main. Working with others. So it meant offering to others a future a vision that they could live with. But also, there was a very specific question: who would decide if Parliament had complied with the principles? And I thought maybe there'll be 5 principles: separation of powers, free political activity, a Bill of Rights, national, regional, local government, and so on. That we ended up with 34 principles, and some had A, B, C, D, E. But it was so useful because it was finding core, like anchors of a new constitutional order, and within that, the Parliament now. But now we were so much stronger in Parliament with a democratic vote. And we had freedom fighters in Parliament. We had a strong women's movement. 30%, 30 out of every 10 ANC people on the list, 3 out of 10 had to be women. So it wasn't like choosing 30% women, men choosing. Elsewhere, the men would choose their wives, their lovers, their daughters. It wasn't really something that came from women. But if there weren't enough high up on the list, then they were pushed up. The branches just chose them. And they were organized. Freni Janwala was the Speaker of our National Assembly. And she said, today, I'm not ANC person who's the Speaker of the House. Today, I'm a woman. And we're not going to hand over power from one gang of men to another gang of men. And they linked up with women from other parties and the National Coalition of Women outside. And it's the most gender-sensitive constitution in the world. Originally, our idea was to have a section, Rights of Women. And one of our persons commented, what do you mean, rights of women? Aren't women voters? Aren't women workers? Aren't women everywhere in the Constitution? We don't want rights for women. And the most important rights for women were in the Freedom Clause, where it's the right to freedom includes the right not to be arbitrarily detained, deprived of your physical freedom, but also the right to freedom from violence from the state or private sources. So gender-based violence became a constitutional matter in 1996. It's a very hot issue in South Africa because sadly it's calamitous, it's very widespread, but it's out there, it's known and it's spoken about, and the people fighting and resisting and taking up the issue. And also it's freedom in that physical sense, but also bodily integrity is in the Freedom Clause and includes the right to make decisions in relation to reproduction. 1996 in our parliament in South Africa. Very powerful workers' rights. The right to fair labor practices is a constitutional matter. The right to strike, the right to form trade unions independent of government. Because we had trade union people in our parliament who'd been in the resistance. Faith communities also supported the struggle, and freedom of religion, belief, and freedom of expression, very strong, not only freedom of the media, but freedom of the universities, autonomy for the universities, of freedom of expression in the universities, and of scientific research, spelled out because university people had also fought for freedom and knew what could happen if you didn't have those things spelled out. So I just mentioned the quality, the significance of our Constitution. And we still remain a divided country, but non-sexism is actually a foundational value equal to non-racism in our Constitution because of the women's movement, because of the struggles in our liberation days, where the women were putting up their hands and saying, even in the freedom struggle, we treated as the supporters of the men who do the fighting, and we don't want to be in that position. That was raised then, so it became a very live issue, and the women's group in Parliament were very, very vehement, and we got that constitution that was so special. So now who's going to decide whether or not the principles have been adhered to? It couldn't be Parliament itself. Constitutional Court. Constitutional Court. And that's why our Constitutional Court became so significant It wasn't simply a creature of the Constitution, it was a creator of the Constitution. And 2 years were given to adopt the new Constitution. It was adopted, they had singing. Thabo Mbeki made a brilliant, beautiful speech about why I'm an African, very, very poetic, and singing, and it's handed over to us, and we set aside 10 days to receive objections from the public. I was in charge of the papers, the documents. We had to allocate, I think, 4 objections in the morning, 3 in the afternoon. We got through 70 objections. And in the end, we said overwhelmingly, the text of the Constitution complies, but in 9 respects it doesn't. And the Constitutional Court of South Africa declared the Constitution to be unconstitutional. We sent it back. Some of the issues were quite big. They made the corrections. It came back to us, and we now said it's okay, and sent it to Parliament, I think on the 4th of December, and on the 10th of December, Human Rights Day, 1996, at Sharpeville, the site of a terrible massacre that was referred to earlier, Mandela signed it into law. And the person who handed him his pen, who was the Secretary of Parliament, who'd also been in the resistance, the underground, said when he handed the pen, Mandela said to him, does it provide for majority rule? And he said, yes, it does, Mr. President. He said, okay, I will sign it. But the key was majority rule together with the Bill of Rights, not power sharing between ethnic groups. And from that point of view, we now have a government of national unity. We have lots and lots of problems, but democracy in that sense is working, and it breathes oxygen into our country, and it gives me hope. It gives me hope that we've solved other huge problems. How do you deal with your former enemies? I'm just going to end with this. I'm in my chambers. Other people have offices. We judges have chambers. The phone rings, and the voice says, there's a man called Henry, says he has an appointment with you. I say, send him through. And my heart's going boom, 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 boom. Henry had phoned me to say he had organized the bomb in my car. He's now going to the Truth Commission. Will I be willing to meet him before he goes? And I open the door, and I look. There's a guy, he's tall and thin, like me, but younger than me, and I see in his eyes, so this is the man I tried to kill. He sees him, this is the man who tried to kill me. We'd never met before. We didn't know each other. We didn't fight over love, money, possession, power, anything. But he was on that side, I was on this side. And we go to my chambers, and he's striding like a soldier. And I try and slow him down with my best judge's ambulation. And we sit down, we talk, and he tells me he was at school, he was so good in school and in the army, and he's so proud of the fact that he rose so quickly in the military to become a senior officer in the hit squad. It's kind of naive, you know, naive. And eventually he tells me about the plan to blow me up in my car in Maputo, Mozambique. And it was postponed for various reasons, and then when the car was blown up, he knew it was the bomb that he had located there. And I stand up, I say, Henry, you have to get on with my work. Normally when I say goodbye to someone, I shake their hand. I can't shake your hand, but go to the Truth Commission, who knows? And when we go back to the security gate, he's not striding anymore. It's like a defeated person. So I forget about him. We work very, very hard. And the end of the year, I'm invited to a party. End of the year for us is summer, and to go to the party with my friend, and the band's playing loud, and I'm there and wanting to relax, and I hear a voice saying, Albie, it's Henry. These were filmmakers, and apparently they were making a film about the 2 soldiers who went to the Truth Commission. And he's beaming, and he comes up to me and he said, you said maybe one day we would meet. I said, Henry, I've only got your face to tell me what you're saying is the truth. And I put out my hand, I shook his hand. I almost fainted. He went away beaming, beaming. But I heard afterwards that he went home and he cried for 2 weeks. I don't know if it's true. I'm not even checking up. I'd rather believe it's possibly true than checking up and finding it's not true. Because it's more important that he cries. His regime and ideology and everything was defeated. He was party to something that he now sees. He tried to kill this person who's willing to shake his hand. He's not my friend. I won't phone him up and say, let's go to a movie. But if I'm sitting in a bus and he sits down next to me, I say, Henry, how are you getting on? And through that small step, he even helped me in a way. That idea of the enemy, that malign force in nature out there that might strike at any moment. Now it's this guy. It's another person. I feel a little lighter, a little easier. So in that sense, the Truth Commission didn't only help him, it helped me. And that's restorative justice. And what was so important in South Africa is we did see changes, real changes, very significant changes, not enough, not quickly enough, and corruption entered into it, and lots of negative things came into it. But if it had simply been a Truth Commission on its own, without political change and some economic and social change, it wouldn't have worked. We get on. It's amazing, actually. I feel it when I land at Johannesburg Airport, and I see our people functioning and working and doing things. And before it was impossible. There was a kind of white arrogance that was so institutionalized, so mechanical, so automatic, so ubiquitous. That's gone now. There's still a lot of white arrogance, assumptions and so on that require attention and dealing with. But we're living in another country. We've made huge changes. And then I always end by presentations by saying that we got our Constitution out of struggle. It's a text. It provides instruments. And to make the Constitution meaningful in the lives of people, more struggle, and more struggle, and more struggle. Thank you. Just before we, thanks guys, I'd like to acknowledge two people, and I was going to say half a person, who were with us in the struggle when it really, really, really mattered, and they're here this evening. Bernadine. I owe a lot to her personally. She introduced the rights of the child, restorative justice. Not introduced it, she brought an energy and a passion and a commitment and functioning things to us in South Africa at a very fruitful time. And it was really, really, really wonderful. And it was wonderful to see how a revolutionary who's trying to bring down the state can become a wonderful master big mama builder, building up a new society, new values. So thank you. And then my old pal, Brixie Nesbitt. First met, I think, in London in exile. 68. And was he passionate? Was he burning? And is he passionate and is he burning? So thanks Brixie, also for what you did. I was just saying today when I went to Bernadine's apartment and we could see Gary, Indiana. You took me there, my first visit to Chicago. And we first went to I think the railway station. Yeah. And I thought I was in Soweto. Except in Soweto, you'd have seen more white faces than you saw on the station. I mean, talk about a kind of ghetto. And we go down to Gary, Indiana. And by the way, nobody's been able to explain to me why it's Gary, Indiana. I know there's a song that says Gary, Indiana, but you don't say Chicago, Illinois. So, in any event, and you take me to a factory and you say, look how terrible it is. You know, the workers don't have a decent parking space for their cars. Now, for a South African, if a worker's got a bicycle, then he's privileged, he's well off. It shows how relative all these things are, but we've had wonderful friendships. And then the half is only in the sense of my great friend Bill Goodman, and he passed not so long ago. And his dad, Ernie Goodman, in Detroit, rather than Chicago, was a wonderful support and friend. And then Bill, we kept up a connection over the years. He came to Cape Town and we climbed Table Mountain. And when I was arrested, we had a photograph of Bill with his rucksack and his boots on, and myself, rucksack and boots on. And the police were sure this was the beginning of armed struggle. And I protected Bill, not that anything could have really happened to him. No, it was a very, very strong connection. And just to say, I'm sure many of you in this room, in your day, you took a stand on apartheid. And really, it was so meaningful. And in the end, that tipping point came when Chase Manhattan Bank refused to roll over a debt. And the cabinet of the old National Party government realized even the American banks that had supported them through thick and thin and every disaster imaginable, even they're not going to allow us to continue. And the banks came as a result of African American community, primarily the basis of the resistance. Then the universities. And it's been a joy for me to discover the universities bragging about, we were the first to occupy the Senate. We were the first to pass a resolution to divest. We were the first. It's wonderful to be associated with that. But at the time, it wasn't so easy. Looking back now, it looks easy. Divestment was easy. Protesting, it wasn't easy. It wasn't easy. But now it's so taken for granted that it was the right thing to do. So thanks to everybody here who helped us in those days, and thanks to everybody here who's fighting for justice and freedom everywhere in the world.
Thank you, Albie. This was a real honor. Thank you. And to use a word of struggle that you know from South Africa, Amandla.
As a judge, I can't say Ngowetu, so I won't say. This is for the Posen Family Center. Wonderful host to me. And it's the preamble to our Constitution.
Oh,
I'll sign it later. And those of you who helped us in our struggle, you helped us to get this. Thank you.
Thank you.
And my organizer reminds me that there's one for Kaushik, which will sign, and one for Tutu.
Oh, thank you. That was wonderful, Albie. Thank you so much. Yes. Yeah.